All right, hello everybody. My name is Galia Aharoni Schmidt. I am the owner of Aharoni Business Law, a business law firm based out of Oakland, California. And I'm so excited today because I have my good friend Rebecca here with me, who is an estate planning attorney. And we are going to talk today about estate planning, especially in particular for business owners, because those are the people I work with and they ask me questions about this all the time. So I am super excited to have you here, Rebecca, to help us answer some questions for some people. So can you just start off by telling us a little bit about you and your firm?
Absolutely. So I'm Rebecca Goldfarb of Goldfarb Luu. My law partner is Din Luu, and together we give our clients peace of mind. We have a great team here, and I think every client really feels like we treat them like family. So sometimes my 5-year-old daughter comes to the office, although not these days, or Din brings her little dog, and it's just a really warm and comfortable feeling. So we only practice estate planning and elder law. And so today I want to talk to you about being a business owner, whether you're a brand new business owner or you've had one for a while. This is the perfect time to start thinking about how to incorporate your business into your estate plan.
Excellent. So can you just start off by telling us a little bit about estate planning?
Absolutely. So it's weird to be on video, so I'm going to look up at the screens so
No
that
problem.
I talk, but I should be looking. So estate planning 101 essentially is about 4 main documents. There are some additional ones as well, but we have limited time today, so I'm gonna really focus on the 4 main ones. So on the left-hand side of the screen is all about your incapacity documents. So once you turn 18 years old, you have to have an advanced healthcare directive so someone can make medical decisions should you become incapacitated. And you need a power of attorney for finance, and that person handles everything else. So they're not making medical decisions, but they're paying your bills and dealing with the CPA for taxes and dealing with Social Security or insurance or signing things on your behalf. And those documents are really, really important for everyone over 18. Your spouse doesn't get to make those decisions for you. You do not get to make them for your 18-year-old kids. And if you have older parents or family members, you can't make them for them either. So it's really important to have those. And we call that the baby estate plan. So it's not about your assets, it's about you turn 18. And if you don't have those, you end up in conservatorship. And I know we're going to talk about that in a little bit. So on the other side, I know I talk about such lovely topics of incapacity and death, but on the other side is your will and your trust. So essentially, they both do the same thing. They say who gets your stuff after you're gone, but they do it in very different ways. And I'll talk more in detail in a little bit, but essentially, if you have over $166,250 and you have only a will, you're going to end up in probate, which is a pretty awful process and it's expensive. If you have a trust, however, then your assets pass without going to court, and it also allows you to control from the grave. So if you have kids, whether they be minors or just young adults, and you don't want them to get everything outright, you absolutely need a trust so that you can kind of sprinkle it over time. We call it controlling from the grave, but you can call it whatever you want.
So I have a lot of clients who are still pretty young, they're single, they don't own a house yet, and they don't have any kids, and I try to tell them to go talk to an estate planner. They're like, but I don't have anything. Why do I need that? So should they still be coming to you?
So for sure they need the baby estate plan,
Okay.
right? That they become incapacitated. But if their business is new and it doesn't really have any assets, then they probably don't need a trust. It's for really when your assets are over that threshold that would trigger probate, or you have kids that you know later on, then you can add to your baby estate plan and do a comprehensive plan with the trust and the pour over will.
Okay. And so let's say you do set up a trust for somebody and they have a business. should they put their business into that trust along with their other assets? And if so, what does that look like? How does it work?
So that's a great question we talk about with every single client. So we look at all of the assets and talk about, does the business have a value or not? So sometimes it will just be kind of a pass-through entity, especially in the entertainment business where people get paid through their entity and then they just pass on those, checks to themselves. And they don't really ever keep a high balance. So we just add that on to, the 166,250 that triggers probate. But that's looking at all of the assets, so not just the business asset alone. And then other times, clearly there are assets or inventory or maybe accounts receivable that could be out there. And so if the business has some good value, or intellectual property or things like that, then we really want to assign it to your trust. So you have full control as the owner. All we're doing is an assignment of your ownership share, 100% or a percentage if you have partners, and assigning it to your trust. And that's really important so that you don't end up in court should something happen, if at incapacity or at death. You don't want these things tied up in court, and you want to make sure that the people you want are in control of your business.
Got it. Yeah, that makes a lot of sense. So another question I get a lot related to this is, let's say I have a business, and even if I did get sued, I don't want them to be able to get any of my money. So if I put a business into this trust, does that protect those assets if I do get sued?
Unfortunately, no. These are just sort of see-through entities to you. They don't have any of that protection. But, we did a video where you were talking about both in insurance and forming an entity to limit your liability. So that is really important to watch. And you can find it linked to this one.
Yeah, absolutely. Yeah, so there are some things you can do to try to protect some of your assets, but that's not the purpose of this trust, right? There's all these other very important reasons to do this, but that's not one of them. So what about taxes? People ask me about trusts all the time for taxes. Does it change taxation in any way if you have your business in a trust?
No, so I assume you're mostly speaking of income taxes. And again, this is just a see-through entity to you. So it doesn't provide any tax benefits in that way.
Okay, that makes sense. And so, all right, so now we have the kind of framework of what an estate plan looks like and what are the different parts. So what happens to your business if you're a business owner if you do suddenly become incapacitated?
So your operating agreement and your estate plan have to work together. God forbid they contradict each other. That could be difficult, but a lot of people will have anemic operating agreements or anemic estate planning documents, and so they're just not addressed. And so we want to make sure that you avoid conservatorship, because that's what will happen if you don't have the proper estate planning documents. So conservatorship is when you are over 18, you have become incapacitated, you do not have an advance directive or a power of attorney, and you have over $166,250, it's going to lead to conservatorship. The court has to appoint someone, your conservator, to take care of your medical decisions. So that's conservator over the person, and also conservatorship over the estate to manage your affairs, whatever is outside of your trust. If you have a trust, or if you don't have a trust, just all of your financial affairs. And unfortunately, this process is very expensive. It's about 10 grand to start. And then because you have to do an annual accounting to the court of all your money, and this is even if you're married and your spouse becomes incapacitated, you still have to do all of this. Wow. And so you have to hire a lawyer and go to court every year and provide this accounting to the penny of a person's money that is spent on them. Wow. So that costs about another $5,000 for the rest of your life. Not to mention that the judge can take all of your rights away. So it could be your voting rights, it could be your driving your driver's license. If you have a professional license, like lawyers, it could be to take your license away. And so it's very, very invasive and avoidable if you have an advance directive and power of attorney. So I cannot emphasize enough how important that is.
Yeah, that's very scary. You want to be able to have control over your business and your life and have the things happen that you want to happen. And it's scary because you were saying, you can have these documents, but they won't be good documents. They'll be anemic. And so there's probably a lot of people who think that the documents they have are good enough and don't realize that this might still happen.
And the other thing is, if you have some incident, an accident or an illness, and you become incapacitated, who's handling your business affairs, right? So if it's your power of attorney, or it's your trustee, or it's a conservator, is that the person you want, or should it be your right-hand person in your business or your business partner, right? And so you want to make sure that your operating agreement addresses this.
Absolutely.
And that way you're protected in that way. We have several clients who have these right-hand people, right? And so in their trusts and in the power of attorney, it's not the power of attorney who's going to be handling this. It's going to be a specific person who can handle the business.
That makes so much sense. These are businesses that people have spent years or decades building, and it would be a shame to have it go to the wrong person just because you didn't have good enough planning documents set up in advance. That's scary. So what about, what happens to a business if a business owner dies?
So it depends if it's probate or trust administration. So probate is the process where you have no will or a will, and you have over $166,250. The beneficiary designation part is separate. So if you have bank accounts and things, and you have Benny designations or retirement accounts, you don't add that money into the $166,000. But a lot of people, you'd be surprised how many Benny designations are wrong, or they don't exist. People assume they did it a long time ago, but they didn't. So we're really looking at all the assets to see if it triggers the probate process. And unlike conservatorship, it doesn't go on forever, but it does last a long time in California. So typically it's at least a year. And that's not with any court closures or anything like that. The idea is you have to lodge the original will. So if you can't find that, then we're going by the laws of intestacy. So it's not who you would want necessarily to inherit. It's what the law of intestacy says who will inherit. It depends who you're, yeah.
I want to repeat that really quick too. No will or a will. I think a lot of people don't realize that even if you have a will, you still have to go through this whole process. I think if you put it in writing, then everything just automatically goes to the people that they put in the will, but that's not true.
Yeah, and so technically speaking, what happens is, let's say I own a house, or in this case, I own a business, and it's in my name, right? And so when I die, who can sign any of the paperwork for anything, because I'm dead? The power of attorney dies when you die. So the judge has to name someone and give them authority to sign those documents and handle your business. Whereas if everything is assigned to your trust or in your trust, your successor trustee just seamlessly takes over. And that's why you don't have to go to court. So, so yeah, wills go through probate if you have over $166,250. So also people will name an executor and they think that's the person who's going to do the administration, but that person will likely have to get a bond, which is an insurance product, that if they run away with the money, there's insurance to cover it. So if they don't have good income, they don't have good credit, they can't do that. So it might be somebody you don't even want handling your affairs. Your assets are frozen for months. So if your family needs to access that money, they won't be able to. We have to notify all creditors. So people come out of the woodwork. It is crazy. And like I said, it takes about a year. So
Wow.
it is also very expensive and totally avoidable. So if you look at this chart and you think about what your assets are, and you go down that first column, mind you, if you have a house, you do not get to subtract the mortgage. So this is fair market value of your estate. And then you go over to column 2, those are the minimum statutory fees that you will pay. So let's just say you have a $700,000 estate. Minimum you're going to pay is $34,000. So I always say, don't waste your money on attorneys, right? Use us when you need us, but be wise about it. So half of that $34,000 goes to the attorney, and half of it goes to the executor or administrator. So really, if you just created a trust, you wouldn't be paying any of those fees. There'd be maybe, depending upon different circumstances, a little trust administration to do, but certainly not anywhere near what the probate fees are.
All pretty scary too. And I think people don't realize that.
Absolutely.
So I see ads online all the time encouraging me to make a will for $100 on some website that's trying to sell me something. Is this the kind of thing that people can do themselves online if they want to?
So I would say no, just like you would say for creating your business entity, for a variety of reasons, but specifically, let me tell you our definition, and then once you learn our definition of a good estate plan, you'll see why you can't do that without an attorney. So first and foremost, this plan should honor your wishes, right? If you become incapacitated, how do you want to be cared for? And then if you pass away, what is your legacy? Who do you want it to go to and how? So we have to dive deep to ask a lot of questions. Most people who come in, if I didn't have any preparation for them to ask them questions in advance, and I would say, what are all your wishes? They wouldn't even know. So if you're doing this online and there are no probing questions, how do you figure that out? Secondly, you want to avoid court, right? I just spent time talking about how expensive it is once we go into court. So if you don't understand all of the nuances, or you pick the wrong people, or you don't fund your trust properly, and we'll talk about that in a little bit, I think, then you're going to end up in court. And so it's really, really expensive. And then finally, and most importantly, I think for everybody, is we want to maintain family harmony. Now, I realize that family harmony might be a little bit of an anomaly. It certainly is with our clients. You know, most people are like, there's family drama all over the place. But we want to do our best to maintain it or minimize it. And so we have all kinds of ideas that are sort of outside of the box ideas to help our clients maintain that harmony. And you just can't do that with no guidance online.
Absolutely. So I think a lot of people believe that every estate planning attorney does the same thing. So what makes you and your firm different from other estate planning attorneys?
So I realize we have really high standards. And so it's not, you know, it's unfair because what I'm about to share with you is based on our standards. But 95% of the estate plans we see coming from other attorneys, when people are coming to do a review or update their documents, they have a fatal flaw. 95% of them have a fatal flaw the client usually doesn't know about. And that is unconscionable to me. People have spent thousands of dollars on these estate plans from good, reputable attorneys, but they're just not focused on the nuances and the details of a particular client family. And I think oftentimes, maybe because they don't do a lot of trust administration, because we do elder law, we see that other side. And so they're not wearing the reality hat when they plan, right? They're wearing their lawyer hat and they tell you what they think you should know. But when you're wearing that reality hat of how does it all seamlessly work when somebody becomes incapacitated or passes away, then we see a lot of problems. So just really quickly, we see outdated documents all the time. I can't tell you how many times we're like, yeah, that was from 1987. Or it was the advance directive was before the law changed. And so HIPAA was not a law. And so without these HIPAA waivers, what it means is your advanced healthcare directive agent cannot receive any information from the doctors. Now, a lot of the times the doctors will violate HIPAA, but you don't want to plan for that, right? We see a lot of missing documents. People will, especially if they do it themselves, although we don't get a lot of those clients, but people will create, attorneys will create an estate plan and then miss the advance directive or miss the power of attorney. And I will tell you from my personal experience, when my husband and I first created our trust in 2002, and that was before I practiced this area of law, he was a really well-known attorney, and he just created a trust for us. There's no pour-over will, there's no advance directive, and there's no power of attorney. And this is from a guy who'd been doing this for 30 years. There wasn't even a discussion about any of those documents.
Wow.
It's shocking. We see a lot of poorly drafted documents, which leads to confusion and misinterpretation of what the person's intent was. People who act without good counsel can go down terrible rabbit holes. You don't want 3 different attorneys giving you a completely different analysis of what these documents mean. I was actually just talking to a doctor friend of mine yesterday, and she said she was in a study about end-of-life decisions by doctors. And so the funniest thing, well, it's not funny, but is that the lawyer is creating the advanced healthcare directive for the doctor to interpret, but we speak completely different languages and we don't understand what these concepts mean back and forth. She said that over 50% of the advanced directives out there are misinterpreted by the doctor.
Wow.
So we really focus on how does the doctor read this, right? What does the doctor need in the ER when something happens, or at end of life planning? Or decision-making time. So it's kind of crazy. A lot of people select the wrong people, right? Because the lawyer just said, well, who do you want in these roles? And without understanding what all the roles mean, they end up picking the wrong people. So we go through every single document and say, this is the responsibility level, this is the skill set the person should have, this is the communication style the person should have, so that you're picking the right people. And then, very specifically with those who have businesses, those clients who have businesses, the trust has to be funded, right? We have to assign that ownership interest to the trust. We had one client where we were doing a trust administration, and we didn't represent the decedent, but she had a lot of business savvy and acumen. She didn't assign the business. It was worth over that 166,000, or at the time, this was last year, it was 150,000. And so we had to go to court and try to pull that into the trust. And it was a huge delay, and thousands and thousands of dollars. So funding your trust is super, super important.
And you had mentioned just outdated documents. How often do you review and update the plans you do with your clients?
So we have lifelong relationships with all of our clients. And so we tell them at the beginning that as a part of our flat fee, that every 5 years, we're going to do a maintenance meeting. If you need it sooner because you've had a life change, right? I mean, these documents need to be updated because our wishes change, our families change, and laws change, our assets change. So whenever there's a life-changing circumstance, we want to do that maintenance, and those maintenance meetings at minimum are every 5 years. If you need it sooner, that's fine. Or I guess every maximum is every 5 years, but if you need it sooner, that's fine. And it's important to talk through all of those issues. I will say that one thing people don't realize, and and I hear this all the time, is they'll say, oh, well, I'll create this when I need it.
Yeah.
And I sit there and kind of pause for a second to say, when you need it is when you're incapacitated or dead.
Yeah.
You can't create it then. You can't create your advanced directive or power of attorney once you lose capacity. So it's really, really important to create these while you can make all these decisions. And really, when you think about it, this is the gift that you're giving the people you love, not to burden them with going to court, with having to deal with family drama, with having all the expense. And so it really is, if you love your family or your friends who are going to be taking care of you, get your estate plan done.
Wow. Yeah. Is there anything else that business owners should be thinking about when they're thinking about estate planning and their future?
So I have to just throw in, a sentence or two about elder law, because we deal with that. We have a lot of baby boomers. So a lot of younger business owners, are starting to take care of family members. So elder law is triggered when you start needing help and those role reversals change. So it's important to go not to the estate planning attorney who helped that parent or grandparent or other family member, but to go to an elder law attorney. We have all kinds of other things and tools in our toolbox that we use to make things happen more seamlessly and resolve issues. And then I think, finally, it's just talk about it. People have the assumption all the time that other people have their affairs in order when it comes to their estate plan, and they don't. I remember years ago, most of my parents' friends are lawyers, and years ago, one of their friends and my former boss died. And everybody assumed he had his affairs in order. He had nothing.
Wow.
So his whole estate had to go through probate, and he had a long-time girlfriend of decades, and legally nothing was going to her.
Wow.
It was all going to his family, and he wasn't super close with them. So it can be devastating not to have this. So talk about it, and it's not maybe normal dinner conversation for most people, but just start talking about what people's wishes are. And then reach out. We're here to answer any questions, and if we can't help you, at least maybe we can answer some questions on the phone.
That's so important. So can you tell us about how to reach you?
So our phone number is up there. My email is up there. Our website is up there. We have social media. I don't do a lot of that, so but it's there. People here, thank God, take care of that. But if you just want to pick up the phone or send an email, we are here to answer your questions.
Excellent. And I don't think I asked yet, can you help people throughout California, or do you focus on LA where you are?
We are licensed to help people everywhere. Now that so much is being done via video, we have more and more people reaching out from the Bay Area and down south and the Inland Empire to create these. So we can help you wherever you are.
No. Well, thank you so much, Rebecca. That was very scary, but in a really good way. I think it's really important information for people to have. I think people have no idea that the consequences can be so bad, and I really do consider it an investment in their future and in their family and friends' future too. So thank you so much for taking the time to explain that to all of us, and it's always good talking to you. And hopefully we can do this again sometime.
I know, we can talk about other issues like
Sounds
employment law and things that are also scary that people
don't. Always fun to talk about. So thanks so much for your time.
Thank you, Galia. Bye.
Bye.